We are on the record in file 18-19189-FC, People versus Michael Davis Fenton. We're here today for a pretrial conference in this case, and we are proceeding today by video conference. Let's see, where did Mr. Lyons, are you there? I think I've lost Mr. Lyons.
Your Honor, this is going to be Miss Wise. She did want to log in for that, so if you could just give me a second, I'll let her know you wanted to call it.
All right, we'll have to wait for Mr. Lyons to get logged back in. I'm not sure what happened to him. Ms. Underwood, we have Mr. Harriston here from MDOC. Do you need to speak with him?
Yes, Your Honor.
All right, Mr. Harrison, I'm going to place you in a breakout session with your attorney. Mr. Mawad, I believe Mr. Samuelson is here in the courtroom. Are you going to need to speak to him?
Judge, I'm not sure if Mr. Fleming is handling this or Mr. Bayonetto. There was an offer made, but I was waiting for a plea agreement, so we can call it if you want. I just wanted to see if anybody shows there's a plea offer made on it. That's all.
Mr. Fleming is not logged in at the moment. Mr. Bayonetto, do you know anything about this one?
Judge, I can check. What is the defendant's name on this one?
Timothy Samuelson.
Okay, I'll check our file.
Okay, let's see. Okay, Mr. Goldstein, I do have Mr. Crone here. Are you going to need to speak with him?
Your Honor, he and I spoke on the phone earlier today, so we're ready to go.
Okay, do we have a prosecutor for Jason Crone?
Yes, Your Honor, that'll be me.
All right. Okay, we're on the record then in file 24-21715-FH, People versus Jason Ansel Crone. We are here today for a pretrial hearing in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bayonetto.
Alex Bayonetto for the People.
David I. Goldstein appearing on behalf of the defendant.
All right, and I apologize. You've got two cases up today, 23-21520-FH and 24-21715-FH. So Mr. Goldstein, where do we stand with Mr. Crone's cases today?
Well, Your Honor, one of the files just recently came up from district court. It's been communication has been a little difficult because Mr. Crone is in rehab. He is in an inpatient rehab in Washtenaw County right now. He anticipates going to transitional housing on the 4th of April. So if we could have an adjournment till say the 10th of April, I think Mr. Bayonetto and I can come to an agreement on these matters. I'd like to get Mr. Crone into transitional housing before we actually enter it.
Okay, Mr. Bayanetto, do you have any issue with that?
No, Your Honor.
Right. You said April 10, Mr. Goldstein?
Yes, Your Honor, it's 2 weeks.
Okay, so let's go with April 10th at 8:15 a.m.
Thank you, Your Honor. Do you need stip in order?
Yeah, if you would prepare a stip in order for each file, I would appreciate that.
I'll get that taken care of. Thank you, Your Honor.
Okay, thank you.
Alex, I'm going to sign your name. Is that okay?
No problem.
Thank you. All right, Jason, I'll talk to you later.
Sorry, Mr. Taylor, we're still waiting on your attorney.
Okay, thank you.
Okay, Mr. Lyons, we're just waiting on Ms. Wise to get logged in for the prosecutor's office.
Not a problem, Judge. I just got a text from her. She says she'll be on shortly.
On the front end. Let's see, so we get back up there.
Sir, go ahead, please.
I need whoever's phone is going off to step outside the courtroom, please. All right, the gentleman at the Lenawee County Jail, can you tell me your name?
What?
Can you tell me your name?
Me?
Yes.
Oh, Barry.
Yeah, that's Mr. Ellison. I represent him, but I don't know why he's on the docket for today.
He has a pretrial.
You know, at the last court date, a review was set for May 27th, I believe.
Oh, May 29th, you're right.
29th.
He was found incompetent to stand trial, but likely restorable, Judge.
And we set a date for May 29th.
Yes.
All right, Mr. Ellison, you can let the officer with you know that we don't need you any longer in court.
So, all right.
We'll see you back on May 29th.
All right, then.
All right, you come back out, sir. Sorry.
Thank you, Your Honor.
Mr. Murphy, I do have Eric Underwood here. Do you need to speak to him?
I do not, Your Honor. I'm ready whenever the court's ready.
Mr. Underwood, are you there?
Yes, sir. I'm here, Your Honor. Let me make sure my camera's on. It's just not showing.
Okay, as long as we can hear you, I think we're all right. So we are on the record in file 24-21704-FH, People versus Eric Underwood. We are here today for a pretrial hearing in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bayoneto?
Alex Bayoneto for the people.
Matthew Murphy appearing on behalf of Mr. Underwood.
All right, and Mr. Murphy, where do we stand with Mr. Underwood's case today?
Your Honor, I was going to ask if we could set a second pretrial on this matter. I wanted to have further discussions with Mr. Bayoneto. I do believe this is the first pretrial, so hopefully that would not be objectionable by the prosecution.
No objection, Your Honor. I believe this is the first pretrial.
All right, let's set it for May 1st at 8:15.
Thank you, Your Honor. My office will prepare the stipulation in order for that date and time.
Okay, thank you. Mr. Underwood, your next date is May 1st at 8:15. You'll log in with all the same Zoom information that you used today.
Yes, sir. May 1st at 0815.
Correct. So you're all set. You can go ahead and log out.
Thank you very much, sir.
Thank you, Mr. Underwood. I'll give you a call next week, okay?
Yes, sir.
Thank you. Thank you, Your Honor.
Thank you, Your Honor. Thank you, sir.
All right, Ms. Underwood, are you ready to proceed with Mr. Harriston?
Yes, thank you, Your Honor.
All right, 1 second.
Mm-mm.
All right, we are on the record in file 24-21684-FH, People versus Ardell Lee Harriston. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Bayoneto?
Alex Bayoneto for the people.
Rhonda Underwood for Mr. Harriston today, Your Honor.
All right, and where do we stand, Ms. Underwood, with Mr. Harriston's case?
Your Honor, Mr. Harriston and I still have a couple things to discuss. I would ask for a short pretrial. Probably maybe a month, Your Honor, if the court has that available.
All right, Mr. Bayoneto, is there anything we need to address from the people's side?
No, Your Honor.
Let's go with May 1st at 8:15.
What was that date again, Your Honor?
May 1st at 8:15.
May 1st?
Yes.
Okay, and I will be happy to do the stip in order with Mr. Bayoneto's permission.
You may.
All right, and Mr. Bayoneto will need the prosecutor's office to prepare a writ.
Yes, Your Honor. I have that noted.
All right. Thank you, Mr. Harriston. You can let the officer that's with you know that you're done with court for today. Mr. Daly, I think we have Mr. Dole here in the courtroom in person. Are you going to need to speak with him? You are muted, Mr. Daly.
Who's in the courtroom, Your Honor?
Mr. Dole.
Dole. I don't have a Dole, Your Honor.
Your Honor, this is Ms. Hennigan. I have Mr. Dole.
Oh, I'm sorry. Do you need to speak with him?
No, I don't, Your Honor. We spoke yesterday.
All right, Mr. Dole, if you'll come forward and sit at the table closest to the television.
Oh, thank you.
All right, we are on the record in file 24.
Don't need it.
File 24-21687-FH, People versus Grant David James Dole. We are here today for a pretrial hearing. In this case, we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Bayanetto.
Alex Bayanetto for the people.
Mayor Hennigan on behalf of Mr. Dole.
All right, and Ms. Hennigan, where do we stand with Mr. Dole's case today?
Thank you, Your Honor. We would like to ask for another adjournment on this matter if Mr. Bayanetto does not have any objections to that. I spoke with my client yesterday and he has informed me of some additional evidence that he would like to provide to me. And he's working on getting that for me. So I would like to get that and have a chance to review it so that I can talk to Mr. Bayanetto about plea negotiations.
All right, Mr. Bayanetto, anything to add from the people's side?
No, Your Honor.
Go with May 15th at 8:15.
Thank you, Your Honor.
So Mr. Dole, your next day is going to be May 15th at 8:15. You can come back to the courthouse in person like you did today, or the bailiff will give you our Zoom information if you want to do it by video conference.
All right, thank you, Your Honor.
All right, so you're all set.
Thank you. Have a good day.
Oh, yeah, Ms. Hennigan, will you do a stipulation in order for the adjournment?
Yes, we will, Your Honor. Thank you.
Okay, I think, let's see, I think we have Ms. Wise here now, so we can do Mr. Fenton's case. So this is file 18-19189-FC, People versus Michael Davis Fenton. We are here today for a pretrial conference. We're proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with Ms. Wise.
Good morning, Your Honor. Jackie Wise on behalf of the people.
And Mr. Lyons?
Good morning, everyone. May it please the court, George Lyons on behalf of Mr. Fenton.
All right, and Mr. Lyons, where do we stand at this point with Mr. Fenton's case?
Your Honor, I've talked to the Lenawee County PD and they have retained, I believe, a Melissa Freeman to handle the appeal. So I anticipate she'll be getting with me sometime this week so I can get her whatever she needs from the file and whatever insight I can share so we can get this thing going.
All right, is there anything else that we need to address today?
Well, there are two things my client brought up. I think I'm not sure what the court can do, but the court needs to know about it. One is that, as the court knows, the MBOC no longer has jurisdiction over my client, and yet he still remains in the Michigan Department of Corrections. They either need to transfer him back to Lenawee or let him go. I don't think there's a third choice. I don't know if Ms. Wise wants to has the position on that.
I agree with you that MDOC doesn't have jurisdiction. I think the judge in the order placed a bond on it. So I think you're correct. I think he would have to come back to Lenawee, but.
Yeah.
All right, so we will contact the warden at Mr. Fenton's facility today and do whatever needs to be done to make those arrangements.
And one more thing he raised, Your Honor. Apparently, there is a halfway house in Adrian that addresses parolees, etc. My client would ask the court to consider his being released to them. It's restricted. It's the work release. I don't know whether or not he qualifies for it, but certainly like the court to consider that.
I would be willing to consider that if I receive more information on whether or not he qualifies and more information about the program.
Right, I would get that in front of the court.
All right. So let's set it for another pretrial. On April 24th and see where things stand. Mr. Lyons, if you want to have your issue addressed before that, you're welcome to contact the court and get an earlier date.
Your Honor, that week I'm having Achilles surgery and I'll probably be fed on my back for a couple of days. Had the surgery that Monday.
How about May 1st would be the next week?
May 1st sounds good.
Okay. And Mr. Lyons, would you be willing to do a stipulation in order for that adjournment?
Yes, Your Honor.
You can sign my name, George.
Not a problem. And that's to May 1st, correct, Your Honor?
Correct.
Thank you. All right.
All right, Mr. Fenton, you can let the officer that's with you know that you're done with court for today.
Thank you, Your Honor.
Thanks, Jackie.
But I have someone logged in at ICF Unit 5. Is there anyone there? Okay, the gentleman at the MDOC facility, can you tell me your name?
There you go. Should be good.
Elijah Bradley.
I'm sorry, I wasn't quite able to hear you.
Pardon?
I wasn't quite able to hear you. Can you tell me your name?
Elijah Bradley.
Okay. Ms. Underwood, do you need to speak to Mr. Bradley?
Yes, please, Your Honor.
All right, 1 second. Okay, Mr. Dagger Margosian, I understand you're handling Mr. Taylor today.
Correct, Your Honor.
Do you need a breakout session with him?
Please.
Okay, 1 second. All right, Mr. Taylor, I'm going to place you in a breakout session with Mr. Dagger Margosian. Okay, Mr. Mawad, are you there?
Yes, Your Honor, I'm here. I'm here.
Okay, do you still need to speak with somebody about Mr. Samuelson, or are we ready to go on that?
We're ready. I've talked to both assistant prosecutors and we can tell you what's going on.
Okay, Mr. Samuelson, you want to come forward and sit at the table? All right, we are on the record in file 23-21614-FH, People versus Timothy Preston Samuelson. We're here today for a pretrial hearing in this case. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Bayanetto.
Alex Bayanetto for the people.
Your Honor, good morning. Elias Muwad appearing on behalf of Mr. Samuelson.
All right, and Mr. Muwad, where do we stand with Mr. Samuelson's case today?
So, Judge, I talked to Mr. Fleming 2 weeks ago about a resolution. I understand, as he has told me, that this is his last week and he was not able to get me a plea offer. So Mr. Bayanetto and or Ms. Wagner are going to talk to Mr. Fleming to try to find out what that plea offer was, put it in writing, and then come back so I can talk to my client. So I'm guessing maybe 3 weeks or whatever the court believes is enough time. Judge, one other thing. I did get a call from the Forensic Center on the issue of culpability. We did get the competency matter back, and he was competent. I told Mr. Fleming that I still like to go through some type of plea on this case, and you know, if the issue of the insanity issue comes up, I'm not sure we're going to go that route anyway. So hopefully we can get an offer, and then I can talk to Mr. Samuelson and move on with the case.
Mr. Bayanetto, is there anything we need to address from the people's side?
No, Your Honor.
3 weeks would be April 17th. Does that work?
It does, Judge.
Let's go with April 17th then at 8:15.
I will prepare the order. Alex, can I sign your name to it?
Yes, you can.
Okay.
All right, so Mr. Samuelson, your next date is April 17th at 8:15. You can attend in person and come here in person if you want, or you can attend by Zoom. The bailiff will give you our Zoom information. You're all set.
Thank you, sir.
Thank you.
All right, Mr. Daly, I've sent an email to the jail for Mr. Bussing, so as soon as he gets here, we'll do his case.
Hello?
Are you Mr. Bussing, sir?
Yes.
All right, Mr. Daly, do you need to speak to Mr. Bussing?
Oh, Your Honor.
Use a minute.
Okay, this is file 24-21728-FH, People versus Harley Victor Bussing Jr. We're here today for a pretrial conference in this case. We're proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Mr. Bayoneto.
Alex Bayoneto for the people.
James Daly on behalf of the defendant.
All right, and Mr. Daly, where do we stand with Mr. Bussing's case today?
Yeah, we were trying to get this resolved by having him cleared for drug court. He was given the assessment by Miss Teskey, and last night Miss Teskey indicated to us that there were some issues with drug court, and she wanted him screened instead for the mental health court. And I told her I would, I thought we could address that today. That's the last information I'd had. We still want to proceed, but now Ms. Teskey wants him screened for mental health court.
All right. Do you know how long we need for that to happen?
I would think we should be ready to go next week. I don't know, Judge. I don't know how long it takes her to screen, but we're ready on our end.
Okay. Mr. Bayoneto, is there anything we need to address from the people's side right now?
No, Your Honor. I believe for ET court, CMH will have to be the one that screens him, though. Perhaps 2 weeks just to be safe. Time to get to the jail. Sometimes I think that can be a bit of a holdup for them.
All right, let's set it for April 10th. That's 2 weeks from today at 8:15. Mr. Daly, would you prepare a stipulation in order for that adjournment?
Yes, sir.
All right, Mr. Bussing, you can let the officer that's with you know that you're done with court for today.
All right, thank you.
Okay, Mr. Rogosian, are you ready to proceed with Mr. Taylor's case?
Your Honor, if you could just give me 1 second, I'm just discussing it with Ms. Weiss.
Okay, Ms. Underwood. Sorry.
You know what? I think we are ready to call that case, Your Honor. Thank you.
Okay. All right, we are on the record in files 19-19313-FH, 19-19314-FH, 19-19315-FC, 19-19367-FC, and 19-19433-FH. People versus David Curtis Taylor. We are here today for pretrial conferences in all of those cases. We are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. Wise.
Good morning, Jackie Wise on behalf of the people.
Your Honor, Michael Margosian for Mr. Taylor, covering for John Glazier.
Okay, and Mr. Margosian, where do we stand with Mr. Taylor's cases today?
Your Honor, my understanding is that we need to get an adjournment on these matters into. We're asking for a time in August. I guess there is a trial scheduled in July that we need to get these past that date.
All right. Ms. Wise, anything to address from the people's side?
No, thank you. I would agree with Mr. Margosian.
All right, let's set it for August 7th at 8:15 a.m.
Thank you.
Mr. Margosian, would you be able to prepare stipulation and orders for those adjournments?
Yes, Your Honor.
Okay. All right, Mr. Taylor, you can let the officer with you know that you're done with court for today.
All right, thank you, sir.
Thank you.
All right, Ms. Underwood, are you ready to proceed with Mr. Bradley's case?
Yes, Your Honor.
All right, so we are on the record then in file 24-21685-FH, People versus Elijah Tremone Bradley. We are here today for a pretrial conference in this case. We're proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record. Is it Ms. Arnold for the People?
It is Alisan Arnold for the People, Your Honor.
Rhonda Underwood for Mr. Bradley.
All right, and Ms. Underwood, where do we stand with Mr. Bradley's case today?
Your Honor, Mr. Bradley is charged with one count of possessing a weapon in prison, Your Honor, a 5-year felony with 4 habituals. The offer on this case is Mr. Bradley would plead to that charge, Your Honor, with 3 habituals. And the prosecutor would Killebrew to a low of no more than 24 months. Your Honor.
No, it's not a cap. It's an agreement of 24. That he would do 24, not a cap, an agreement of 24.
I thought you said I could. Okay. Never mind. Well, the prosecutor would agree to a cap of 24 months.
No, it's not a cap. Both parties would agree he would be sentenced to 24 months on the minimum is our offer.
Okay. Right. A minimum of 24 months.
Right.
And another charge that Mr. Bradley has pending would not be prosecuted, Your Honor.
Judge, if he wants to accept that agreement, I can do a written plea and send it to Miss Underwood, and she can read it to him and sign his name on it, and we could proceed that way.
All right, so he wants to accept that plea agreement, Ms. Underwood?
I believe he does, Your Honor. Mr. Bradley?
Yeah.
Do you recall our discussions?
Yes.
And is that what you just heard?
Yes.
Do you want to accept that?
Yes.
All right, do you understand, Mr. Bradley, that the agreement is that you will be sentenced to a minimum of 24 months?
Yes. Your Honor.
All right, would you raise your right hand?
I got cuffs on.
Okay, just do it to the extent you can and let me know when you have.
Yes, Your Honor.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
You are Elijah Tremone Bradley?
Yes.
Mr. Bradley, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, prisoner possessing weapons?
And Judge, that is with a habitual offender 3rd offense notice, and we're dismissing the 4th offense notice.
Is it your intent to plead guilty, Mr. Bradley, to count 1, prisoner possessing weapons?
Yes.
Is it also your intention to admit the 3rd habitual offender?
Yes.
Understand that as a result of the 3rd habitual offender, the maximum possible penalty for this offense would be up to 10 years in prison. I'm sorry, was that a yes?
Yes.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed on the record here this morning. Is that correct, Ms. Underwood?
That's correct, Your Honor.
Yes, that's correct, Your Honor.
All right, Mr. Bradley, if a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at trial and have the witnesses against you appear at your trial and ask those witnesses questions. You have the right to have order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Bradley, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
And do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about August 31st, 2023 in Madison Township, Lenawee County, Michigan, that you did commit the offense of prisoner possessing weapons?
Yes.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Bradley to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Bradley, other than as we've discussed on the record this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
Yes, Your Honor.
She's told you something other than what we've discussed on the record this morning?
No, Your Honor.
Okay, so the only thing that she's told you is what we've talked about with the 24 months, is that right?
Yes, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
All right, Ms. Underwood, would you like to cover the factual basis?
Thank you, Your Honor. Mr. Bradley, on August 31st, 2023, were you transferred to the Gus Harrison facility in Madison Township, County of Lenawee, State of Michigan.
Yes.
And you were at that facility, correct?
Yes.
And at that time, you had secreted a piece of metal that could be used as a weapon in your anus. Is that correct?
Yes.
And that was found by the scanner.
Yes.
And you had no right to have that secreted in your person.
No, ma'am.
And you know that's a violation of both prison rules and the law.
Yes, ma'am.
I believe the factual basis. And Mr. Bradley, I'm sorry, but as to the habitual offender, Mr. Bradley, were you convicted on 1/16/2013 of the offense of breaking a building with
Yes.
intent?
Yes, ma'am.
6th Circuit Court, in the 30th Circuit Court for Ingham County in
Yes.
Michigan?
Yes.
And on or about 2/8/2017, were you convicted of the offense of criminal sexual conduct, 3rd degree, in the 30th Circuit Court for Ingham County in the state of Michigan?
Yes, ma'am.
I believe the factual basis is sufficient, Your Honor.
Ms. Arnold?
I agree.
Okay, does the court comply with MCR 6.302 B, C, and D? Ms. Arnold?
Judge, I just have one question. I just wanted to make sure that Mr. Bradley, maybe this is covered already, that he understands that this is an offense for which consecutive sentences.
You understand that, Mr. Bradley?
A little bit.
Mr. Bradley, do you remember us talking about that this was a crime committed in prison? So it
Yes.
is consecutive.
Okay. Judge, I'm satisfied.
All right, Ms. Underwood?
I'm satisfied, Your Honor.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Bradley has had full knowledge of his rights and he's had competent counsel. Court has not made any agreement regarding the possibility of a plea or possible sentence in this case with prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than, as we've discussed on the record here this morning. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for May 2nd at 8:15 a.m. Mr. Bradley, someone from the Lenawee County Probation Department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background. And so, Ms. Arnold, we're going to need a writ for the sentencing hearing. I'm just looking up Mr. Bradley's file now to see whether we have fingerprint information to know whether that needs to be in person or by Zoom.
Did you say in person, Your Honor?
I don't know yet. I'm looking that up. That can be a Zoom writ. We do have his fingerprint information. Unless Mr. Bradley wants to be here in person, he has a right to do that.
Mr. Bradley, would you rather be here by Zoom or in person?
Pardon? What was that?
They want to know if you want to be here in person or by Zoom.
Not in prison, no.
I'm sorry, Mr. Bradley, the microphone's a little difficult to hear you. Can you tell me what your answer is again?
So not in prison.
You want to be here in the courtroom in person for your hearing?
On person, yes.
Okay, so we'll need an in-person writ for Mr. Bradley for his sentencing here.
I've got a note, Your Honor. Thank you.
Okay, thank you. All right, we are all set then. Mr. Bradley, you can let the officer with you know that you're with court for today.
Okay, thank you.
Thank you. Okay, Mr. Malero, are you ready to proceed with Mr. Jenkins?
Yes, Judge.
Are you on?
All right, we are on the record in file 22-21198-FC, People versus Dakota Brian Jenkins. We are here today for a pretrial conference. In this case, we are proceeding today by video conference and in person. First, let me have the attorneys place their appearances on the record, beginning with Mr. Hartung.
Thank you, Your Honor. Good morning. Doug Hartung, appearing for the people today.
Salvatore Malero on behalf of Dakota Jenkins.
Okay, and Mr. Malero, where do we stand with Mr. Jenkins' case today?
Your Honor, I believe we have reached a resolution of this matter. Mr. Jenkins will be pleading guilty to amended information count 2, accessory after the fact to a felony, a 5-year felony in the Class E category. The plea agreement also carries a Killebrew agreement of no immediate jail.
Mr. Hartung, is that a complete and accurate statement of the plea agreement?
The only differentiation would be that the court would retain the option to impose a sentence, but it would be suspended from our perspective, as either way is fine with us, Your Honor.
Mr. Malero, does the defendant agree with that?
You understand? Yes. So the judge could like make a sentence of some kind of jail time. Not impose that immediate jail. Either way, you would. Understand? Yes, we understand, Judge, and we're willing to go for it.
Okay. Mr. Jenkins, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Dakota Brian Jenkins?
Yes.
Mr. Jenkins, you've heard the statement of your attorney and prosecuting attorney. Is it your intention to plead guilty today to count 2 on the amended information, accessory after the facts to a felony?
Yes.
And you understand that the maximum possible penalty for that offense is up to 5 years in prison and or a $10,000 fine?
Yes.
Are you satisfied with Mr. Malero and the advice that he's given?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record this morning. Is that correct, Mr. Hartung?
Yes, Your Honor.
Mr. Malero?
That is correct, Judge.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you right now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial. If the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you were guilty, and you do not have to prove anything. You have the right to be present at your trial and to have the witnesses against you appear at your trial and ask those witnesses questions. You also have the right to have the court order any witnesses that you have for your defense to appear at the trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Jenkins, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial? Can I have you speak a little louder?
Yes, I do.
Get your voice caught in the recording. Do you also understand that any appeal from the conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right?
Yes.
You are not a citizen of the United States of America. Conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've described to you?
Yes, sir.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about May 28th, 2022, in the city of Adrian, county of Lenawee, that you did commit the offense of accessory after the fact to a felony? Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
You understand that if I accept your plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter that plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than in plea bargain to induce Mr. Jenkins to plead guilty?
No, Your Honor.
No, Judge.
Mr. Jenkins, other than as we've discussed on the record here this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty?
Yes.
All right. Mr. Mayor, would you like to cover the factual basis?
Yes, Judge. Thank you. Dakota, is it true that on or about May 28th of 2022 in the city of Adrian, county of Lenawee, state of Michigan, that you were engaged with Zachary Rosenberg? Yes. I don't mean, relationship wise, but you met with him to facilitate a drug transaction? Yes. The felony that was committed was he sold you some drugs, yes? And after he sold you some drugs, you, with an intent to aid him by avoiding detection or arrest, did not report that to the police. Yes. And is the state satisfied with that recitation?
I am, Your Honor. I am, Mr. Malaro.
All right.
All right. Has the court complied with MCR 6.302 B, C, and D, Mr. Harton?
I believe it has, Your Honor.
Mr. Malaro?
Court has, yes.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Jenkins has had full knowledge of his rights and he has had competent counsel. Court's not made any agreement regarding possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we discussed it on the record here this morning. I will refer this matter to the probation department and set sentencing for May 2nd at 8:15 a.m. Mr. Jenkins, the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background. And as soon as we're done here, which is in just a second, you're going to need to step across the hall to the probation department. They'll have a packet of information that you're going to need to take with you and fill out and return to them. Okay. All right. So you're all set for today, and we'll have you back on May 2nd for the sentencing hearing.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Judge.
Thank you. All right, Ms. Hennigan, I believe we have Mr. Kennedy in the jail Zoom room.
Great, thank you, Your Honor. Could I have a breakout session, please?
Yeah, just as soon as they get their audio connected, I'm going to send them a message. Oh, okay, so the audio is connected now. Sir, you're Mr. Kennedy, correct?
Yeah.
All right, I'm going to place you in a breakout session with Ms. Hennigan, if you give me just a moment. I can't see a person even. Okay, Mr. Bennett, are you there?
Yes, Your Honor.
I do not believe we have Mr. Jones logged in or here in person. Do you know anything about where he is today?
I actually sent him a text message just a little while ago. I gave him the Zoom ID this morning. We discussed this hearing yesterday. So I don't.
I'm here logged in.
Oh, yes.
I'm
Okay.
sorry. Let me change your name, Mr. Jones.
I'm sorry. This is just the Zoom ID. I'm trying to.
Okay, we're all set. Give me just a second to get your file. All right, we are on the record in files 23-21615-FH and 23-21616-FH, People versus Maurice Leroy Jones. We are here today for pretrial conferences in both of those cases, as well as pretrials on contempts, alleged contempts for violating bond conditions. First, let me have the attorneys place their appearances on the record, beginning with Ms. Arnold.
I'm Alisan Arnold for the people.
Morning, Your Honor. For the record, my name is Jeffrey Bennett. I'm appearing with and on behalf of Maurice Jones. I'd indicate that his video is off, but I do recognize his voice.
All right, sir, you're Maurice Leroy Jones?
Yes.
All right, so Mr. Bennett, where do we stand with these cases today?
Your Honor, I've had discussions with Ms. Arnold regarding a resolution. We've been unable to resolve it at this point. My understanding is that there's going to be an additional case charged, which will be a felony. And I don't know, there's going to be also a 404B to try to use the evidence in all of these cases and each of the other cases, which would probably necessitate one trial if that's successful. So we can either set it for trial or we can wait for the other case to catch up. I don't really have a preference.
All right, Ms. Arnold, how long would you anticipate needing for a trial?
Well, Judge, it's going to be dependent. I think that we have a good chance of succeeding on our 404B motion. And in speaking with Mr. Bennett, if we do, I asked him if his preference would be to have one trial or have multiple trials with the 404B evidence. And he said one trial. I think because we would be combining 3 incidents into one, I think we would need probably 3 days for trial. If we're not doing that, I think the trial length could be a little shorter. I'm not sure. I haven't had a trial with Mr. Bennett. I don't know how quick he is. We might need 4 days, but I think 3 would do it. If the court wants to secure some trial dates and set them out, I can authorize that other charge and we can look at combining later on. Or the other thing we could do is I could authorize that charge. I could file a motion on the 404B issue or a notice, which I'm sure Mr. Bennett will object to probably, and then we could resolve that and then set trial dates. I think either way would work.
All right, I think we're, as a practical matter, looking at probably July or August at this point for 3 days. So I would imagine that would be a sufficient amount of time to get the other issues resolved. Is that fair?
Yes, Your Honor.
Yes, Your Honor. And if I have any input in it, July is a bad month for me.
I think July is already fully booked anyway, so,
Okay.
Sierra, do you have our book?
I do, Judge.
Okay, so we need 3 days, probably, I guess, start looking in August.
And Judge, I have limited availability in August, so it's gonna depend on the 3 days.
Okay,
So our first 3-day period would be beginning August 13th, be the 14th and the 15th.
Yeah, that's not gonna work for me. Does the court have availability the week of the 26th? I know starting then I'm completely free for an extended period.
It looks like we do the 27th, 28th, 29th, and 30th. So any combination of those.
If that would work for Mr. Bennett, that's great for me.
Yes, I'm available that week.
okay, so did I hear the 27th, 28th, and 29th?
Yes, Judge.
Okay. All right, so trial will be set then on the August 27th, 28th, 29th.
But for now, does the court want to say it's 23-21615, and then we can modify that if we need to?
Yeah, let's do it that way. So 23-21615. And then if we add those, we'll add them for the same dates. So let's do a final pretrial. Can we do August 21st at 8:15?
Judge, you were off that day.
No, so we would need to go to, let's see, you said you were not available, Ms. Arnold, on the 14th, is that right?
Yeah, that
So we'd have to do August 7th?
I'm available on the 7th.
Judge, my problem is the week of the 5th and the 12th, I'm planning on being out potentially, I don't know which week, potentially both weeks. So could we do the 22nd possibly and do it on an off day, or the 20th?
Let's see, so we can. Yeah, I could probably do the 22nd at 8 a.m.
Judge, you were off that whole week.
I'm off that whole, yeah, I'm taking,
If we set it for the 7th now with the thought that we can move it if I'm gonna be gone, I think that would work.
right.
Or I can have someone else cover it.
All right, so we'll set it for August 7th then at 8:15. All right, so I'm also looking through the files so that everyone is aware, particularly Mr. Bennett. I do have a new warrant that was recently signed that alleges a positive drug test on March 11th and failure to test on March 14th.
Your Honor, I believe, yes, I talked to Mr. Jones yesterday about that. My legal assistant, I think, has been in communications with pretrial services about this warrant. I explained to Mr. Jones that after today, just like last time, he's going to have to return. But I also believe that the violation for failing to test is going to be dismissed, as Mr. Jones was in custody in the Washtenaw County Jail that day.
All right. All right. Is
I
there
would
anything else we
indicate,
need
I
to?
do physically have the warrant, so the motion and warrant.
Judge, I don't know what the court customarily does in these situations, but Mr. Jones has tested positive previously on these cases, and was not placed in custody. I don't, I have an issue, and the offense that I have not yet charged yet was committed while he was out on bond on the offense that's set for trial. So I think given all those circumstances, he should potentially be remanded, or we should look at some jail time for the violation.
All right, so it is a warrant. So Mr. Jones either needs to turn himself in on the warrant, or he'll be arrested when he's found.
Okay.
Right, and I would indicate for the record that Mr. Jones was given a bond the last time. He did turn himself in after the last pretrial, and we arraigned him a couple of days later, and he was released. So it's not like the court hasn't imposed bonds for these alleged violations.
All right.
Judge,
Well, again, I'm sorry, what is it?
will we be setting a pretrial for the 616 file as well?
Yeah, let's set that for the same August 7th date.
Not gonna read the scoring for the SRT, or are we?
All right, is there anything else we need to address today?
I just want to confirm that the court will be sending us a scheduling order.
We will in the 615 file. Can you, Mr. Bennett, do a stipulation in order to adjourn on the 616 file to the August 7th date?
I will do that, Your Honor.
And you can sign my name.
Thank you, Ms. Arnold.
Thank you.
All right, Mr. Jones, you can go ahead and log out.
All right.
Thank you, Your Honor.
Okay, Mr. Daly, who do you have left?
Mulholland and Maples.
Mulholland and Maples.
Oh, all right. Let me see.
On Maples, Your Honor, I would indicate to the court there's nothing we can do. He just completed the evaluation, so we're just waiting to get the results back.
Yeah, I did get a letter about that they've just done the interview. Do you want to do anything on the record, or are you okay just adjourning it?
I'm okay with just adjourning it.
And Judge, I called the psychiatrist who did the evaluation and left him a message, but I have not heard that there's a report yet.
Okay.
There is a report.
How about April 24th?
That's fine with me, Judge.
Sounds good.
We'll do April 24th at 8:15. Mr. Daly, could you do a stip in order to adjourn?
Yes, Your Honor.
And then okay, and then you had Mr. Mulholland.
Yes, Your Honor.
Is he at your office?
Yes, Your Honor.
Okay. Let me do Mr. Kennedy first, and then we'll do Mr. Mulholland.
Okay.
Okay, so we are on the record in files 23-21426-FH, 23-21427-FH, and 23-21578-FH, People versus Daniel Martez Kennedy. We are here today for a pretrial conference in each of those cases, and we are proceeding today by video conference. First, let me ask the attorneys place their appearance on the record, beginning with Mr. Bayoneto.
Alex Bayoneto for the people.
Maurice on behalf of Mr. Kennedy.
Okay, Ms. Hennigan, where do we stand with Mr. Kennedy's cases today?
Thank you, Your Honor. Mr. Kennedy was scheduled to have trial on one of these cases last week. He has recently been charged with some new charges, and the plea agreement was withdrawn right before his deadline to take it due to the new charges that were pending. So at this time, we would like to ask for another free trial to be set on all of these cases, so that we can have an opportunity to see if there may be an offer for a global plea that would include the new charges. And then Mr. Kennedy can make a decision about whether or not he still wants to go to trial.
Where do we stand with the new charges? Is there a preliminary exam set yet?
The public defender's office has not assigned me to those charges, so he'll be having a second public defender attorney that will be working with him on those. However, he was recently arraigned and bond was set, so he should be very close to going through getting to his preliminary exam on those. I believe those are in Judge Morgan's court in district court.
They are, Your Honor. I'm trying to pull up the case right now. The case is actually set for arraignment this morning. So he'll be arraigned on it this morning. And then there will be PCC and a preliminary exam set after that.
All right, let's go with May 1st, I guess. So May 1st at 8:15. Ms. Hennigan, would you prepare stipulation and orders for those adjournments?
Yes, Your Honor. Could you tell me that I have the case numbers for 426, 427, and there was a third case number from this morning, so I could get those correct on the stip and order?
The last one is 21578.
Thank you, Your Honor. Mr. Bayoneto, may I sign with your permission?
You may.
Thank you.
Okay, Mr. Kennedy, you can let the officer that's with you know that you are done with court for today. Okay, Ms. Underwood, you need a breakout session with Mr. Madrid. Okay, let's call the Mulholland case. All right, this is file 23-21438-FC, People versus Michael Sean Mulholland. We are here today for a pretrial conference in this case. We are proceeding today, I'm sorry, for a motion hearing in this case. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Arnold.
Alison Arnold for the people.
James Daly on behalf of the defendant, Turner.
All right, and so we're here on a motion in limine to use an excited utterance filed by the people. Ms. Arnold, if you have any arguments you'd like to make, you can proceed.
Judge, I know the court's aware of the charges in this case, and the allegation underlying the charges is that the defendant digitally penetrated the vagina of his 7-year-old daughter. His daughter likely went to bed in her room around 9 o'clock that night. That is substantiated by her mother on May 30th, 2023. At about 1 in the morning on May 31st, 2023, the defendant's daughter's mother, I'm just going to call her child. The child woke her mother around 1 in the morning, had a deer in the headlights stare, and told her mom right away without prompting that the defendant got into bed with her and put his hands down her pants and touched her private area. She was crying while she described this, and she told her mom that her teacher told her if someone touched her private area to tell someone, and kept asking why daddy touched her private area. That was 1 in the morning on the 31st. She was examined on June 1st and had 2 lacerations inside her labia majora, on her labia minora, and bruising around the area. That was diagnosed by an experienced sexual assault nurse examiner. As everyone's aware, the excited utterance exception to the hearsay rule allows an excited utterance if it's a statement relating to a startling event or condition made while the declarant was under the stress or excitement caused by the event or condition. The stress or excitement has to be enough to overcome the likelihood that the victim fabricated the statement. Here, I've cited 3 cases for the court. Actually 4 cases for the court: People versus Smith, People versus Layer, People versus Souls, and People versus Draper. All cases involving sexual assault on children, and all finding that there's no express time limit for excited utterances. And in all of those cases, they extend the time much longer than the time frame in which Morgan disclosed to her mother that this incident happened. We know it happened somewhere between 9 and 1 in the morning. And in Smith, a 16-year-old disclosed 10 hours after a sexual assault. In Layer, a 15-year-old disclosed to a therapist 1 week after a sexual assault. In Souls, a lapse of 5 days was allowable. And in People versus Draper, there was a 1-year delay when a 3-year-old was sexually abused by her stepfather. This is a matter of at most 4 hours, could be less. The victim was crying during the disclosure, and the victim had significant injury to her genital area. I think it falls squarely within the exception, and we would ask the court to allow the statement of the child to her mother as an excited utterance.
Mr. Daly.
We have nothing else to add. We would rely upon our brief in regards to that issue, Your Honor.
All right, I have had a chance to review both the people's motion as well as the brief. I do believe that this falls within the excited utterance exception. I think obviously the alleged sexual assault would be a startling event. In People versus Smith, the Michigan Supreme Court indicated that it's the lack of capacity to fabricate, not the lack of time, that's the focus of the excited utterance rule. And in this case, I think that that applies, although there was a period of time between the alleged event and when the child spoke to her mother about it. She was in the presence of Mr. Mulholland the entire time, and at the first opportunity went to her mother's room and told her mother about, or made the statement to her mother without any prompting. So I find that it does fall within the 803.2 excited utterance exception. I also, in looking at the 803A exception, think that it appears to fall within that exception as well as the statement of a child statement about a sexual act. As I read through the motion, I think that all 5 requirements in that exception would be met as well. So I would find that the statement is admissible under both of those rules.
Your Honor, we just have a couple of housekeeping matters for trial. In our notice of support, we listed Carissa Zubke, who is a victim advocate in our office, as the person who would sit in as a support person. Ms. Zubke is no longer employed by our office. She's now working in the administrator's office, making more money than she was in our office. So we'd like to change that support person to Christina Kidney, who is a victim advocate, who also has a similar level of contact. The child has only met her a couple times, but we'd like her to sit in as the support person. We also submitted an affidavit to the courtroom about closing the courtroom. The court reserved ruling on that issue, or said it would grant the issue, I believe, if we submitted an affidavit. So I've submitted an affidavit by Melanie Mulholland, who is the child's mother, and I would ask that we close the courtroom as stated in the request of that affidavit. And finally, we do have photographs of the injury to the victim's genital area, and I've told Mr. Daly on a couple of occasions that I wasn't going to send those to him because of the sensitive nature unless he really wanted a copy, but he's free to review them here at any time. And if he needs a copy, we will provide those with probably a protection order in place, but we're happy to do that.
All right, so any issue, Mr. Daly, with the change in the victim advocate?
No, Your Honor.
All right, and I did receive a copy of that affidavit. I did, I think, reserve a ruling on the issue of closing the courtroom pending receipt of that information because it wasn't addressed previously and it's a part of the statute. So now, having had that, I do think it is appropriate to close the courtroom to all unnecessary persons during the victim's testimony. So I will order that at this point as well. All right, is there anything else that we need to address with the case today?
Yes, Your Honor. As things have developed in this case, there's now a need, we believe, to have some of these issues examined by an independent specialist. We filed a petition to have these experts added. We don't have an order back on that yet, but we would ask for an adjournment to consult with some independent experts, particularly in the area of the sexual assault, also having to do we have an expert that we want to use as it relates to alcoholism. And with the developments that have occurred recently, we would ask for an adjournment to get these things in place. It shouldn't be more than 30 days that we would need. Maybe more than 30 days, but depends how quick our witnesses come together.
All right, I don't know that I've received or seen any petition on that yet.
Ex parte order.
Doesn't mean it had been.
That's set for Monday. And we filed it on Monday.
So we have a hearing set for Monday on that?
No, we just filed it Monday, so you may not have it yet.
Okay.
Judge, I sent you a chat message about that.
All right, so we'll try to, I don't believe I've seen it. So we will try to find that. I guess let me ask Ms. Arnold, what is the people's position on that?
Judge, it's always been my position that it's, up to the court whether to appoint expert witnesses or not in a given case. I think that's between the court and the defense. Regarding the alcoholism expert, though, I would question it. I'm not really taking a position. I'll just point out I would question the need for that because criminal sexual conduct first degree is not an offense where intent is an issue. I guess it would be on the second degree count, but it's not on the first degree count. So I just point that out on the record. Obviously, we're ready to go to trial on Tuesday. We would prefer to go to trial. This has been adjourned previously. We have a 7-year-old victim, but we don't want to undercut the defense's ability to present a fair defense to the defendant. So my only request would be that we decide no later than Friday morning whether there's going to be an adjournment of trial, because I have several witnesses that we have planning on coming in, 2 of whom are experts who've cleared their schedules to be available.
Okay.
And then my other request would be that if we adjourn trial because we're going into the summer months, that the court give us a couple potentials and we be able to call our witnesses in advance and make sure they don't have scheduled vacations. So we don't schedule a trial and then have to file a motion for adjournment, if we could do it that way.
Okay. So what I'll do is have an answer to you by the end of the day. And if in fact we end up adjourning, we will work with you to identify a couple of dates or make sure we can work with the experts so that we have everybody available when we schedule the trial.
Okay, I appreciate it, Judge.
All right. Anything else for today?
No, Your Honor.
No, thank you, Your Honor.
All right. Thank you. Then I think we're all set on that. Okay, Ms. Underwood, are you ready to proceed with Mr. Madrid?
Thank you, Your Honor. Yeah.
Okay, so we're on the record at file 23-21441-FH, People versus Alejandro Luis Madrid. We are here today for a hearing on a probation violation. We are proceeding today by video conference. First, let me ask Ms. Underwood to place her appearance on the record.
Rhonda Underwood for Mr. Madrid this morning, Your Honor.
All right, and sir, you are Alejandro Luis Madrid?
Yes, sir.
Right, Ms. Underwood, where do we stand with Mr. Madrid's case today?
Your Honor, Mr. Madrid is being given a bond hearing this afternoon on a new case of retail fraud downstairs, Your Honor. I think under the circumstances, I would request a week or 2 adjournment to see what happens there and to consult with Mr. Moore in terms of that situation, Your Honor.
Okay. We can set it for next week, April 3rd at 8:15.
Thank you very much, Your Honor.
All right, so Mr. Madrid, you can let the officer that's with you know that you are done with court for today.
All right.
Okay, Mr. Malero, you have Ms. Marshall?
I do, Judge.
Okay. Is Ms. Marshall here or?
She's not in the courtroom. She usually shows up.
Not have anyone in my Zoom room right now.
Yeah, let's see here, Your Honor. So Miss Marshall does not have a residence. So I've been messaging her, and I did send her notice of this pretrial. And she was in court the other day on something else downstairs. So I can't account for why she's not here.
Okay, we are on the record in file 24-21707-FH, People versus Page Bree Marshall. We are here today for a pretrial hearing and proceeding today partially in person and partially by Zoom. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Bayoneto.
Good morning, Your Honor. Alex Bayoneto for the people.
Salvatore Malero on behalf of Page Marshall.
All right, and we had a brief discussion off the record regarding the fact that Ms. Marshall is not currently present for the hearing. Mr. Malero, is there anything you'd like to state on the record with respect to that?
I would, Your Honor. As I said just a moment ago, she doesn't have a residence, so I'd arranged to her, I would text message her notices. I did do that for this date. That said, Judge, she has appeared in all the district court cases in person. But I cannot account for why she's not here today. I did message her. She did not respond yet. I would ask the court to either consider an adjournment or if the court's not going to do that and issue a bench warrant, to give me perhaps 48 hours to round her up.
All right, Mr. Bayonetto, anything that people would like to address?
Your Honor, given her failure to appear, I think a bench warrant is appropriate. If the court does want to hold that for 48 hours to give Mr. Malaro a chance to track her down, I wouldn't have any objection to that.
All right, I don't see any other instances of a failure to appear in this case by Ms. Marshall. I would note that the charge in this case is fleeing and eluding. I do think that one of the charges, I do think that it is appropriate to allow the 48-hour grace period because she doesn't have a prior failure to appear. So I will do that, but if we have not located or heard from Ms. Marshall within that 48 hours, I would at that time issue a bench warrant and set bond on the bench warrant in the amount of $1,000.
Thank you, Judge. Have a nice day, Judge.
Mallory also. Mr. Malero, you had an arraignment for LaShawn Perkins.
I thought we submitted a waiver on it.
Waiver.
I don't see, I thought I signed a waiver. I know it said he gave me permission to waive it.
Judge, I do not show a waiver on that file.
Check. Oh, Judge, my secretary said she messed up. She saw my note, but she didn't do the waiver.
Okay. So you've got one coming.
Yeah, or yeah, could we adjourn a week? And sorry, it's crazy at our office.
Yeah. Okay. This is a Judge Anselm case. Why don't we adjourn that to next week, and then when you get the waiver filed, she can give you a retrial date.
That'd be great, Judge.
Your Honor, we had Ryan Davis on our calendar. It was originally set for final pretrial today, but it looks like the trial was moved. Was the final pretrial also moved, or the pretrial vacated?
If we looked into that yesterday, yeah, everything's been moved to like May.
Yeah, the only thing I can tell you at the moment is somebody crossed that one off of my list, and Mr. Malero says we've got new dates in June.
Yeah, there's a scheduling order because we tracked that down yesterday.
Okay.
So I'm confident that it was moved. I don't know why, but it was. Because he called me, he was a little frantic about it.
Okay.
So. Thank you, Judge.
All right, I think we're all set.
Now I'm all set.
Yeah.
All right.
Okay, Ms. Let me. So we can do Julia Betts. All right, we are on the record in files 22-21100-FH, 23-21264-FH, and 23-21519-FH. People versus Julia Rayanne Betts. We are here today for hearing on a summons for probation violation in each of those cases. We're proceeding today both in person and by Zoom. The record should reflect that the summons indicates that Ms. Betts was ordered to appear this morning at 8:15 a.m. It is now 10:11 a.m. Ms. Betts has not appeared either in person or by Zoom at any point this morning to respond to the summons for probation violation. I am going to issue a bench warrant for the failure to appear, and I'm going to set bond on the bench warrant in the amount of $10,000 cash or surety in each file.
I think it kills all your good bacteria.
Okay, Ms. Underwood, you need to speak to Mr. Matson.
Yes, Your Honor. Thank you. Yes.
Your Honor.
Yeah.
Is there an Alex Peck in the courtroom?
No, there is not.
Okay, I'm wondering if we could call that case.
Yeah. Yeah.
Judge, Mr. Coast is in training, wanted to be present for that. Let me go tell him that you're calling that case.
Okay. This is file 24-21732-FH, People versus Alex Dominique Peck. We are here today for a pretrial conference in this case. The court also had issued an order to show cause with respect to an alleged probation violation for this morning at 8:15. We are proceeding today by video conference. Court is also open to the public. First, let me have the attorneys place their appearances on the record, beginning with Mr. Bayoneto.
Alex Bayoneto for the people.
Your Honor, Michael Dagger Margosian for Mr. Peck, covered for John Glazier.
All right, so the record should reflect at this point that Mr. Peck was ordered to appear in court this morning to respond to a order to show cause. He is not present in the Zoom session or in person here today. It is now 10:17. Mr. Peck's not been present at any point this morning. Mr. Dagger Margosian, is there anything that you would like to address at this time?
Well, Your Honor, what I will say is that, as indicated, I am covering for Mr. Glazier. I don't know if I'm looking through the file notes. I don't know if Mr. Glazier has had any outside contact with Mr. Peck. I tried to call the contact information that we have. I was unsuccessful. I will indicate that Mr. Peck is young. He's a 21-year-old. And I believe that this is the first pretrial. So again, I don't know if he was aware of this morning's court hearing. So the show cause notwithstanding, I would ask the court to, rather than issue a bench warrant, I would ask the court to maybe order an additional show cause. And again, if Mr. Glazier has some arrangement with Mr. Peck, then we could resolve it that way.
Judge, I too have tried contacting him, left a message on his phone. He failed to call me back. Since this, the violation for missing drug test, I count 4 additional missed drug screens as well.
Let me see, Mr. Bayoneto, what do you think people want to address?
Your Honor, given that he has kind of dropped off the map in even responding to Mr. Coast, I think the fact that he's failed to appear today, a bench warrant is appropriate. Again, that given he's young and the nature of the charges, I wouldn't object to a 48-hour hold, but as even Mr. Coast can't get a hold of him, I would say a bench warrant is definitely appropriate here.
All right, I just want to make sure I understood Mr. Coast clearly. So there are 4 additional missed tests since the last one referenced in the order to show cause.
That is correct, Judge.
All right, so that would mean he has missed 8 tests total beginning on February 15th and essentially has not tested since.
That is correct.
I think under those circumstances, with respect to failing to appear on the summons, I don't think he's entitled to the 48-hour notice on that. And I don't, under the circumstances, think it would be appropriate since he essentially has just stopped testing altogether at this point. So I am going to issue a bench warrant for failure to appear on the order to show cause. I'm going to set bond on that bench warrant in the amount of $25,000 cash or surety.
Thank you, Judge.
All right, thank you. I think that's all for this case. Okay, so Ms. Underwood, I'm going to bring Mr. Matson back from the breakout session, but I am aware there are two Robert Matsons at the jail. And so I think one is Robert Matson the fourth. Do you know which Robert Matson you were speaking with?
I believe this is Robert Matson the third, Your Honor.
Okay, so this is the Robert Matson that is on probation in this court.
Yes, I believe so.
All right, I just wanted to make sure, and then Sergio, could you run across the hall and see if you can find Mr. Matson? Yes, sir. Yeah. Okay, we are on the record in file 21-20513-FH, People versus Robert Joseph Matson. We are here today for a hearing on a probation violation, and we are proceeding today by video conference. Mr. Matson is present from the Lenawee County Jail. Mr. Matson, my court notes indicated that at the last hearing, you waived your right to be represented by an attorney. I am required to advise you at all stages of the proceeding that you do have a right to be represented by an attorney. And if you can't afford an attorney, the court will appoint one for you at public expense. Do you understand that?
I don't think you'd be violating your oath of office, Your Honor, by allowing me to the right to a fighting clause.
Sir, I didn't ask you about any of that. I asked you if you understand.
I will, however,
Mr. Matson, don't interrupt me. The question I asked you is whether you understand that you have the right to be represented by an attorney.
I do understand I have a right to be represented by an attorney or not. Yes, sir.
Okay. You've previously waived that right. As I said, I have to advise you that at every stage of the hearing. So I have to ask you again, would you like to be represented by an attorney at this point?
As I started to say, Your Honor, I don't want the representation. However, I will use the help of handling paperwork due to my means here and having access to certain things in paperwork. I will use your court-appointed attorneys just to help with some paperwork.
Okay, so you don't have a right to have the public defender's office do your paperwork or handle any of that. You have the right to have them represent you or not represent you. So that
Nope.
is your choice.
Not represent me, that's fine then.
All right. So you've previously been arraigned on the probation violation. Do you know how you want to proceed? So your options are you can plead to it if you want, which means you'd be admitting guilt. The other option is that I can set it for a hearing and we can have a hearing on the matter, and then I'll decide based on the evidence submitted at that hearing.
Your Honor, all due respect, I wish, are you working under oath of office today, sir?
Sir, I'm not going to answer these questions or deal with this. We've dealt with you before and your sovereign citizen arguments. I've rejected them all.
Citizen.
Sir, do not interrupt me. Do you want to have a hearing or do you want to plead?
I'll take your silence under your oath, Your Honor.
Okay. Do you want to have a hearing or do you want to plead?
I want the hearing. I want to go to trial. I want to go within the 90 days to a trial or sooner.
All right. So Sierra will need about a 1-hour hearing on a probation violation.
As well as I'd like you to have the arresting officers that arrested me on that day. I would like their sergeant to be dressed in uniform and at that trial on that day as well, please.
Judges, tomorrow too soon?
That is probably going to be too soon, yes.
You could do 3:30 on Monday, April 8th.
Actually, the subpoena, no, the prosecutor's office does. Everyone's subpoena.
Do we have anything else open that week? I hate to do it on a Monday because I never am certain that that's actually going to end at 3:30.
You have a jury trial the rest of that week. It looks like Wednesday. You have a prelim in a juvenile case at 2:30. I'm not sure how long that will last.
What is the jury trial?
The jury trial is Tory Marshall. You could do an 8 a.m. on Friday the 12th, and I can move the couple of sentencings.
No, let's do it on Monday then. We'll do it on Monday, May 8th. April 8th, I'm sorry. Monday, April 8th at 3:30. Mr. Matson, do you want to be present in person for that hearing or do you want to do it by Zoom?
It doesn't matter. Judge, whichever is best for the court should be fine with me.
All right, I think it will go more smoothly if you are here in person, so we will have you in person here from the jail.
All right, exactly what the hearing is going to be on that day?
So you've been charged with a violation of the terms of your probation.
Yeah.
For failing to report. So the hearing is going to be to determine whether or not you failed to report.
Okay, so it's going to be the trial that day.
Correct.
Okay, can I have the state police sergeant there at that trial?
What state police sergeant?
The state police sergeant of the arresting officers on the night of my arrest.
Who are the arresting officers?
I don't remember the exact names. But any state police sergeant in uniform would do.
Why do you want any state police sergeant to be present at the trial?
Just just to show how arrests are made, and why they're made, and how they do, the determination, how they bring people into jail.
Well, how is any of that relevant to whether or not you violated the terms of probation?
I believe there's a lot of relevancy there. I don't
All
see
right,
where
so-
I don't see where any of it's going to affect the courts in any way, shape, or form.
All right, so the issue that the court is going to determine has nothing to do with things that happened during your arrest. The issue is whether or not.
It's not about the arrest. It's about the arrest for the violation of probation as well.
All right, the only issue before the court that day is going to be whether or not you reported. So your arrest doesn't have any relevancy to that. So I'm not going to.
I beg to differ, Your Honor. I beg to differ, because the jury is going to be a jury of my peers, and at this time,
sir,
you're not going to have a jury of my peers.
Sir, there's not going to be any jury. You're not entitled to a jury trial on a hearing about violating your probation.
I'm sorry, I misunderstood. I'm pretty sure that last time I spoke to you, you said that I had the right to a jury trial for determining if I was guilty for a violation of probation.
I've never seen you on this violation of probation.
I've seen you, or I've seen you just the other day, last week.
No, you didn't. A different judge conducted that hearing.
You're Michael Olsaver, aren't you? There was
Judge
Sloan, and then there was you. I've seen both.
You did not see me last week.
I did.
And so you're not entitled to a jury trial on a probation violation. So again, we will have you back in person on.
Well, hold up then. So if I'm not entitled to a trial to determine if I'm guilty or not, this is a criminal court, isn't it?
It's a criminal court where you have already pled guilty to a felony and been placed on probation.
Because I was at risk of dying in this.
I've muted Mr. Matson's device because he continues to interrupt me and not let me finish what I'm saying. Mr. Matson, I was saying that this is a criminal court wherein you have pled guilty to possessing a controlled substance, and you were placed on probation. As a result of that, your sentence was to be placed on probation. Subsequent to being sentenced to probation, there was an allegation that you failed to report in accordance with the terms of your probation. That is an alleged violation of probation. There's no right to a jury trial for a violation of probation. So the court will conduct.
Let me speak to.
I've muted Mr. Matson again because he unmuted himself and interrupted me. We will have you back on April 8th at 3:30, Mr. Matson. This hearing is concluded.
Your Honor, did we handle Mr. Vasquez's case yet?
No, I don't have. I think Mr. Noe is his attorney, and Mr. Noe has never logged in this morning. He's in the same situation as Mr. Taylor. Is that?
Yes, Your Honor. I'm covering that for Miss Wise, and she was going to have me asked to adjourn it to that same date. I just wanted to make sure I didn't miss it. So.
Why don't we plan on doing that, and then maybe you or somebody at the prosecutor's office can contact Mr. Noe and get his agreement to adjourn.
Okay, I'll give him a call right now.
Okay. So let's see, Ms. Underwood, I contacted the jail about Darius Collins. And I've also contacted them about Mr. Gordon, but don't have him.
About who?
Sorry. Mr. Gordon, but he's not yours, I don't think.
No.
Your Honor, I have Teresa Perez. I didn't know what the
Oh,
court's intention was.
So, yeah, her father passed away. I got a note about that yesterday. So, do you want to just adjourn that to a new date?
Yes, if we could, please, Your Honor. Whatever fits the court schedule best is fine with the defense. Yeah, I guess probably maybe a couple weeks at least, I assume. So
Yeah. How about April 17th? That would be 3 weeks.
yes, Your Honor, that should work. Thank you.
Okay. Could you do a stip in order for that adjournment?
I will, Your Honor.
Mr. Banetto, were you handling the Teresa Perez case? I think Mr. Murphy's probably on the phone with Mr. Noe's office. If you want to just get in touch with Mr. Banetto, assuming it's okay with him, we'll just do a stip in order.
Yes, Your Honor. Thank you. Everyone have a good day. Thank you, Your Honor.
Thank you, Mr. Murphy. All right, so Ms. Underwood, as soon as we get Mr. Banetto back, we will, I guess we'll have to do something on the record with respect to are there 2 MDOC cases left?
Okay. Your Honor, on Mr. Collins, that's an AG case.
Okay.
Can we arraign him and set a quick pretrial without an AG? I don't.
Your Honor, I was able to reach Mr. Noe about Mr. Vasquez whenever the court has a second.
Okay. Is that August 7th date all right with him?
It is, Your Honor. Mr. Noe, for some reason, didn't have this on his calendar. He's driving back from spring break right now. So I did tell him that it was our intention to set this for August 7th, and he said that date was fine with him, and he did want to extend his apologies to the court for that.
Okay. All right, let's call the Takota Alberta case. All right, so we are on the record in file 24-21686-FH. Takota, People versus Dakota, Stephen, Alberta. We are here today for pretrial conference in this case. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Banetto.
Alex Banetto for the people.
Ron Underwood for Mr. Alberta, Your Honor.
All right, and Mr. Alberta is a inmate with MDOC. I did have one MDOC facility that logged out before I was able to determine who was in that MDOC facility. I don't know if that was Mr. Alberta or not, but they are no longer here. And so I believe we have to adjourn this to another date because Mr. Alberta is not present. I can do April 24th at 8:15 if that works.
That works for the people, Your Honor. I'm putting in a note for right now.
Thank you.
That's fine with the defense, Your Honor.
All right.
And I will do the stip in order with Mr. Bayonetto's permission?
Yes, that's fine.
Okay, thank you very much. And so I believe we have Mr. Collins at the jail. Ms. Underwood, do you need a breakout session with Mr. Collins?
I don't believe so, Your Honor.
So we're on the record in file 24-21767-FH, People versus Darius Dwayne Collins. We're here for arraignment in this case, and we're proceeding today by video conference. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Collins today, Your Honor.
All right, I would note we did have someone from the Attorney General's office logged in earlier for the court cases, but she is no longer logged in. Ms. Underwood, does Mr. Collins wish to have the information read?
One moment, please, Your Honor. I don't see where we have a copy of the information, Your Honor.
Okay, you know what? I'm looking through the file. I don't have information either. I only have complaint and just a complaint.
I'm sorry, Your Honor.
I apologize. So I do not have an information either. Why don't we pass this for the moment, and we'll see if we can contact the Attorney General's office.
Thank you, Your Honor.
Okay. Okay, Ms. Underwood, let's call Jeremy DeVries.
I believe Mr. DeVries is in the MDOC, Your Honor.
Yeah, we didn't have him logged in, so we're just gonna have to adjourn this.
Okay, great.
Okay, so we are on the record in file 24-21759-FH, People versus Jeremy Allen DeVries. And we're here today for, this was set for arraignment today. We are proceeding today in person and by video conference. First, let me have the attorneys place their appearances on the record, beginning with Mr. Bayonetto.
Alex Bayonetto for the people.
Ron Underwood for Mr. Debris this morning, Your Honor.
All right, and this was set for arraignment today. However, Mr. DeVries, who is an inmate with MDOC, is not present. We do have a Zoom writ for him. However, he's not logged in at this point. I don't know if he was logged in earlier. Again, I had that one MDOC facility logged in, but I could not determine who or even if anyone was there. So I think we need to adjourn this one as well. And can we do April 17th on this one?
What was that date, Your Honor?
April 17th.
April 6th?
17th.
Oh, 17th.
Okay, we are on the record in files 22-20700-FH, 22-20701-FH, 22-20831-FH, and 22-21137-FH. People versus Caleb Matthew Young. All of these are set for hearing today on a summons for probation violation. The record should reflect that Mr. Young was ordered to appear in each of these files this morning at 8:15 a.m. It is now 10:50 a.m. and Mr. Young has not appeared either by Zoom or by being here in person. So Mr. Young has failed to appear to respond to the order to show cause. I am going to issue a bench warrant in each of the files at this point, and I'll set bond on each bench warrant in the amount of $10,000 cash assured. Okay, Mr. Dagger Margosian, I had also had you for an arraignment on Mark Regalado.
Yes, Your Honor.
Do you know where he is today? He's not here.
Your Honor, I tried to make contact with him. His ability for communication is pretty limited. So I don't have any information on where he is. He was present in district court. I don't know if he's just confused on when and where to be today, but I don't have any more information.
Okay. We are on the record in file 24-21763-FH, People versus Mark Shane Regalado. This is set for arraignment this morning. We are proceeding today by video conference. Courtroom's also open to the public. First, let me have the attorneys place their appearance on the record, beginning with Mr. Bayoneto.
Alex Bayoneto for the people.
Your Honor, Michael Dagger Margosian for Mr. Regalado.
All right, and record should reflect this matter was set for arraignment at 8:15. Mr. Regalado has not appeared. It's now 10:52 a.m. Mr. Regalado is not logged into the Zoom session, and he is not present here in the courtroom. Mr. Dagger Margosian, if there's anything you'd like to say with respect to that issue, you can go ahead.
Your Honor, the only thing I'll add, other than what I just addressed with the court off record, is that Mr. Regalado waived his preliminary exam in this case with the intention of entering a plea, as well as he has two other district court cases, and those cases would be dismissed pursuant to this plea agreement. So, and those, he has a pretrial on both of those about a week from today on April 5th. So I guess I would ask the court to adjourn this case for today until after that date. He would be required to be in person in district court. So maybe if he shows up on that date, then I would be able to let him know what's going on with this circuit court case.
All right, Mr. Bayoneto, anything people would like to address?
Your Honor, Mr. Regalado, he's a habitual fourth. He's got a pretty significant record. He was given the date for arraignment in district court. I think a bench warrant is probably appropriate on this, given that it is just a retail fraud. I wouldn't object if the court held the bench warrant for 48 hours, but I again think a bench warrant is appropriate.
All right, so he obviously has failed to appear here today. As far as I can tell, this is the first failure to appear in this file. And so what I'm going to do is I'll adjourn this arraignment to April 10th at 8:15 a.m. If Mr. Regalado does not appear for that hearing, I would treat it as the second failure to appear, in which case he would not be entitled to any grace period. I would immediately issue a warrant for him at that point.
Thank you.
Oh, I'm sorry. That's a Judge Anselm case. I was just handling that arraignment for her. So, yeah, I think looks like she ought to still be able to do that on the 10th. So April 10th, but that'll be before Judge Anselm, not myself. Okay, and so Mr. Dagger Margosian, we have contacted the jail for Mr. Gordon. So we're just waiting for them to bring him to us.
Your Honor, regarding Catrice Edwards,
Yeah,
I thought that our office had filed an arraignment waiver on that.
you know what, maybe you did, because I don't have the file. Let me. Oh, yeah, I'm sorry. You had, I did have a note on my docket and I missed it. So, yeah, we do have a waiver on that one.
Okay, thank you.
Okay, and Ms. Underwood, the Attorney General for Mr. Collins' case has apparently been waiting in Judge Anzalo's Zoom room because he or she was not aware that I was handling Judge Anzalo's cases today, so we ought to have that person in a minute.
Thank you, Your Honor.
Good morning, sir. Are you Mr. Gordon?
Yes, I am.
Mr. Dagger Margosi, do you need to speak to Mr. Gordon?
Yes, please, Your Honor.
All right, one second. Mr. Gordon, I'm going to put you in a breakout session so you can talk to Mr. Dagger Margosian. If you give me just a moment.
Okay.
Mm.
Elijah Bradley's the guy that fled. The second one.
Is that the one in person that was behind like a cage? Yeah. What was that again, Bradley?
Elijah Bradley.
Elijah Bradley, thank you. When did he come back? May 2nd.
Yes.
Yeah. Do you want to be in person?
Okay, we can't start. Okay, we are on the record in file 24-21761-FH, People versus Alisan Gordon. We are here today for an arraignment. In this case, we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Bayoneto.
Alex Bayoneto for the people.
Your Honor, Michael Dagger Margosian for Mr. Gordon.
All right, yeah, and Mr. Gordon is here by video conference from the Lenawee County Jail. Mr. Dagger Margosian, does Mr. Gordon wish to have the information read?
No, Your Honor, we'll waive the formal reading of the information. We are prepared to enter a plea on the case.
All right, you want to state your understanding of the plea agreement? I'll ask Mr. Bayoneto to confirm.
Your Honor, in district court, Ms. Wagner, APA Wagner and I agreed on a waiver of the preliminary exam, and in circuit court, Mr. Gordon would be pleading guilty. There should be an amended information sent to the court, and Mr. Gordon will be pleading guilty to count 3 felony possession of a firearm and count 4 controlled substance possession. Additionally, he will be screened for drug court, and in exchange for that, counts 1 and 2 and the habituals would be dismissed.
Okay, I do have information that has the added count 3 of felon in possession of a firearm and count 4 possession of cocaine, heroin, and other narcotic less than 25 grams. So, Mr. Bayoneto, is that a complete and accurate statement of the plea agreement?
It is, Your Honor, yes.
Hopefully, like 5 minutes.
All right. Mr. Gordon, would you raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Alisan Gordon?
Yes, Your Honor.
Mr. Gordon, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 3, possession of a firearm by a felon?
Yes, Your Honor.
You understand that the maximum possible penalty for that offense is up to 5 years in prison and or a $5,000 fine?
Yes, Your Honor.
Is it also your intention to plead guilty to count 4, possession of cocaine of less than 25 grams?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $25,000 fine?
Yes, Your Honor.
Are you satisfied with Mr. Dagger Margosian and the advice that he's given you?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Bayoneto?
That's correct, Your Honor.
Mr. Dagger Margosian?
Correct, Your Honor.
Mr. Gordon, if a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them.
Okay.
You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Gordon, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application of leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've described for you?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about September 26, 2023, in the city of Adrian, county of Lenawee, that you did commit the offense of possession of a firearm by a felon?
Guilty.
And how do you wish to plead to the charge that on or about September 26, 2023, in the city of Adrian, county of Lenawee, commit the offense of possession of cocaine less than 25 grams?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No, Your Honor.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Gordon to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Gordon, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
Mr. Dagger-Magosian, do you want to cover the factual basis?
Mr. Gordon, on September 26th of 2023, were you in the city of Adrian, county of Lenawee?
Yes.
All right. And on that date, did you have in your immediate possession a firearm? Did you have a pistol at your house?
Yes, Your Honor. Yes.
All right. And do you agree that on or about November 13th of 2006, you were convicted of what's called a specified felony?
Yes.
That felony being delivery and manufacture of controlled substance?
Yes.
All right. And that would be in Wayne County, third Circuit, Wayne County.
Yes.
All right. And so you did not have a legal right to own that firearm on September 26th of last year?
No.
Okay. And on that same date, did you possess cocaine?
Yes.
All right. And it was less than 25 grams?
Yes.
You didn't have a legal right to possess that cocaine?
No.
Okay. I'm satisfied.
Mr. Bayonet?
I'm satisfied, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Mr. Bayonet?
I believe it has, Your Honor.
Yes, Your
Mr.
Honor.
Dagger-Magosian? All right. I will accept the plea. It's been given understandably, voluntarily, accurately. Mr. Gordon has had full knowledge of his rights and he has had competent counsel. The court has not made any agreement regarding the possibility of a plea or a possible sentence in this case with the prosecutor, defense attorney, defendant, when acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation. And we set sentencing for May 1st at 8:15 a.m. I'm sorry, May 3rd is what I meant to say. That's Friday, May 3rd at 8:15.
Your Honor, if I may address bond briefly.
Okay, go ahead.
I'd ask the court to consider a personal recognizance bond for Mr. Gordon. The reason, really the main reason being he does have Crohn's disease and he has been incarcerated for approximately 9 days. When we waived the preliminary exam in district court, he was remanded based on alleged failures to do drug testing. We have a hearing on that situation this afternoon. I would expect that the district court will, if a plea is entered on that, I would expect the district court to grant credit for time served on that matter. But obviously he's still being held in. I believe that he's still being held in on this. If there is still a PR on the underlying case, then I guess I don't even need to address anything. But if the bond had been changed, I would ask the court to grant the PR bond based on his health issues. And also he does indicate that he has a job and he can do the testing at this point.
Okay, give me just a second to look up the file and see if there's a bond on this or what that situation is. The only bond I see on this was that there was a $2,000 personal recognizance bond that has been posted.
All right. In that case, I will just address the bond situation with district court this afternoon.
Okay. I would just remind Mr. Gordon that the bond conditions that were in place in district court remain, so that there still is the drug testing 2 times per week provision. You need to coordinate that with Darren Coast in the circuit court trial services, and I will let Mr. Coast know about this situation so that he can get in touch with you.
Thank you, Honor.
Okay, I think we're all set then.
Thank you.
Judge, I would just add that if he does get released, he needs to come to our office to give us all the information.
Oh, yeah, I apologize. So, Mr. Gordon, I am referring this to the probation department for a pre-sentence investigation. When you get released, you need to come right over to the courthouse on the 3rd floor, go to the probation department, and you have to pick up some forms to fill out and set up a date for your interview.
Okay.
Okay?
Yes, Your Honor.
All right, you are all set with this court for today then.
Okay.
Okay, and then Ms. Berta, I did not have an information for Darius Collins.
Yes, Your Honor. It was my understanding it was scheduled for an arraignment today. When I spoke to Judge, sorry, I'm drawing a blank on her name, Anzalone, she thought that they had all been waived. All the arraignments had been waived. Miss Underwood represented him in the lower court. But she could not locate the waiver form. So then she told me that you were going to handle anything for Judge Anzalone.
Yeah. I can do an arraignment, but I don't have an information for.
I have received a copy, Your Honor.
Judge, I just got that. I will forward it to you now.
Oh, right. Okay, so give us just a second and I will print that as soon as I get it.
All right, thank you.
Okay, let's see. So we are on the record now in file 24-21767-FH People versus Darius Dwayne Collins. We are here today for an arraignment. In this case, we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Berta.
Yes, Your Honor. Christy Berta from the Attorney General's Office for the People.
Rhonda Underwood for Mr. Collins this morning, Your Honor. Thank you.
All right, and Ms. Underwood, does Mr. Collins wish to have the information read?
I don't believe so, Your Honor. We would waive the reading of the information, acknowledge its receipt and the receipt of the witness list and request for discovery, Your Honor. At this time, we would ask the court to enter a not guilty plea on Mr. Collins' behalf and set this matter for a very quick pre-trial, Your Honor.
Right. I'll enter a not guilty plea for Mr. Collins. I could set this for next week, April 3rd.
That's fine, Your Honor.
I'm not sure that we're going to have coverage because of the spring break issues, Judge. We've had some struggles with that. I know this week, if we could bump it at least another week after that.
Oh, yeah, I'm sorry. This is Judge Anzalone's case, so let me look at her schedule. Okay, let's go with April 10th then at 8:15.
Thank you, Your Honor.
Thank you, Your Honor.
I already have court on April 10th.
And that works out.
Was that?
And that works out.
Okay.
Okay, so Ms. Collins, you can let them know that you are all set with our court for today.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. And then Ms. Underwood will contact the court or the jail for Mr. Rakes right now.
Thank you, Your Honor.
So, all right, we'll get out of here. Yep.
Come on.
Yeah.
Okay. You all set? You all set? Were you all set?
Yeah.
Interrupted.
Good job.
They couldn't wait. Working on it now, man. You'll probably find. Yeah, top shelf in the property room behind the door, that flat that has shit on it. They did their top.
Okay, Ms. Underwood, do you need to speak to Mr. Rakes?
I do not.
Okay. We are on the record then in files 21-20570-FH and 21-20656-FH, People versus Devin Dean Rakes. We are here today for hearing on probation violations in each of those cases. We are proceeding today by video conference. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. Rakes this morning, Your Honor. Thank you.
All right, and Ms. Underwood, do you know where we stand with Mr. Rakes' case?
Absolutely, Your Honor. Mr. Rakes is scheduled for a probable cause with Mr. Malero this afternoon on the underlying charge that forms the basis of this violation, Your Honor. So we would respectfully ask the court to continue the not guilty plea and set this over for a week or two to see what happens there.
Okay, let's set it for April 10th at 8:15.
Thank you, Your Honor.
Is there any way I could say something?
Let me put you in a breakout session with Ms. Underwood and you can discuss what it is you want to say with her.
Do you want to break out, Mr. Rakes?
No, I was just gonna ask if my bond could be changed to $1 because I'm bonded out and I'm not getting time served.
So you're bonded out on this one?
Yes, yeah, I'm bonded out on the violation, yes.
Okay, so yeah, I'll look at that and make sure if you don't have a bond on this one, I'll give you a $1 bond so that you'll get credit.
Thank you very much.
Thank you, Your Honor.
Okay. Yep. All right. Anything else then for Mr. Rakes today?
I don't believe so, Your Honor. Thank you.
All right. Mr. Rakes, you can let them know that you're all done with us.
Thank you very much.
Okay.
I believe unless you have something else, that concludes my docket for the morning, Your Honor.
I believe that's everything that I had. So thank you very much and
Thank
have a
you.
nice day.
Is there anything you need us to do with Mr. Vasquez's case, Your Honor? Or is the court?
Just get a stipulation in order signed by Mr. Noe and get that filed, I think is all we need.
Okay, sounds good.
Okay, thank you very much.
No problem. Have a good day.
You too.